The largest employment support package in Australian history passed Parliament this week. The $130 billion JobKeeper package has already seen more than 700,000 businesses register for the fortnightly payment of $1,500 for workers. And here to discuss the details of the package is employment law expert from Resolution 123, Carly Stebbing. Good morning to you, Carly. We've got a lot to talk about. Let's start with, when will workers receive the JobKeeper subsidy?
Okay, so the government is telling us that the Australian Tax Office will start processing the payments from May, and that workers will be entitled to be back paid the JobKeeper payments to the 30th of March, and that we can expect the subsidy to continue until the end of September.
And Carly, how much will JobKeepers receive?
They are going to receive the greater of the $1,500 per fortnight, or their normal wage for the hours that they work. So something that's really important under the scheme is that workers are entitled to have their base hourly rate guaranteed. Okay, an employer can't reduce their base hourly rate under the scheme. So if you work more hours than $1,500 worth of hours at your hourly rate, then you are entitled to be paid for those additional hours. Otherwise, you'll get the $1,500 minimum.
And can employers stand workers down at all?
Yeah, so under the scheme, there's five, they call them JobKeeper directions. So there's 5 different types of directions that employers can give to employees in order to help get them through this period. The first is that they can stand you down from your duties, okay? And in a different turn, that if you've already been stood down from your duties, they can actually call you back to work and ask you to perform duties that are within your skill and competency. Another thing that they can do is they can change your hours of work and your days of work, and that might include reducing your hours of work and your days of work. They can ask you to work from a different location. That's meant to facilitate people working from home, but it also enables an employer to give a reasonable direction to work at a different location than your home that you're able to attend. Another is that they are able to direct you to take your annual leave, and that can be at half pay, so you can take up to double the amount of leave at half pay, as long as you retain an entitlement to 2 weeks balance. And I think I've covered them all off. Duties, changes to duty. Oh, and the other one is the change to duties, so that the employer can direct you to work different duties.
You're making it sound a lot clearer. There's a lot to get through. What if, Carly, a worker can't comply with these changes?
Okay, so an employer has to give an employee 3 days notice of any of the changes that they're proposing. So if they give you one of these job directions, they need to give you at least 3 days notice. They need to give you that writing in person, and they need to give you the opportunity to consider that. You're allowed to have a representative participate in the discussions, and the employer must consult with you about those changes, which basically means the employer needs to give you an opportunity to express your views about whether or not the changes are reasonable, how they affect you. They need to take those views into consideration before implementing the change.
And what if a worker is made redundant during the stand down?
Okay, so a few things around these changes. One brilliant thing is that it is acknowledged in the legislation now that if you raise a dispute, so if you disagree with the direction that has been given to you, or you can't comply with it for some reason, or make a complaint about it, or you can't reach an agreement with your employer, they are all protected workplace rights, okay? So you are entitled to make those complaints or make your views heard, and if it can't be resolved with the employer, then you are entitled to commence a dispute with the Fair Work Commission and have that dispute resolved. The employer cannot take any adverse action against you because you've raised a complaint or a dispute. If they do, it is unlawful adverse action, and that includes that the employer cannot dismiss your employment because you've made a complaint or been unable to comply with the JobKeeper direction. The JobKeeper directions are only available to be made to employees where an employer has a reasonable basis to understand that the job will continue to be required to be performed beyond the 28 of September timeframe. Okay, so it is not intended to falsely keep people in jobs that jobs aren't going to exist outside of that timeframe. If the job is genuinely redundant, then the employer is entitled to make you redundant. They need to comply with the usual rules and regulations around a genuine redundancy, and your entitlements, including to accrue leave over the duration of any stand down period, and to notice, redundancy pay, and your accrued leave on termination are all protected under the reforms. So you get paid notice, redundancy pay, and your accrued leave as though any direction around the JobKeeper provisions hadn't been made.
And Carly, in the past 28 days, your firm alone has had a 1,000% increase in people looking for information about their rights during the COVID-19 outbreak. What resources are available?
Okay, so we've had a tremendous uptake in employees looking for information about what their rights are at work, particularly around situations where they're being forced to take unpaid stand down or being forced to take pay cuts. Some of the things that we're doing in response to that is that we're hosting a weekly Facebook Live over on our Resolution 123 Facebook page at Resolution 123 AU. And another thing that we've done is we've launched what we call a Covert Express consult. So in order to get through this volume of inquiries, we're now offering our clients a 20-minute consult. You can book that over on our website, resolution123.com.au. It's $99 and may very well be the best $99 you've spent if we can help you to retain your job through this period. There are government resources available, so you can go to the Fair Work Commission's website, which is fwc.gov.au. They've got brilliant resources available, as do the Fair Work Ombudsman at fairwork.gov.au. And for the mums and dads businesses out there, I get it. This is hard and it is confusing. There are great support groups available on Facebook, including one run by a fabulous law firm called Her Lawyer. You can head over to herlawyer.com.au. They've got some brilliant information about coronavirus and how it's affecting employers. And Her Lawyer are also hosting a Facebook group where you can get up-to-date information and interact and ask questions from other small business operators.
Yeah, it certainly is overwhelming information, but you're making it so much clearer in such an emotional time for everybody. Thank you so much for your expertise, Carly, employment law expert from Resolution 123. Thank you so much.
Thank you.
Stay safe and well.
Happy Easter.
Happy Easter.